Hi everyone, Assalamualaikum warahmatullahi wabarakatuh. To my Muslim student, we are going to continue with our second topic regarding to factors vitiating the contract. Previously, we have looked into the general differences between void and voidable contract. So now we go to the second category under factors vitiating contract, that is void contract. Okay, previously we have seen the characteristic between these two. So today we are going to focus on void and illegality. Why we focus on these two? Because some of the illegal issue will become the contract to be void. So at the end, the implication considered similar, that is void. Okay, so in terms of the linear outcome, of course, I expect my students that are able to identify the scenario that lead the contract to be void. Okay, what are the difference between the void and voidable, and whether this scenario has the legal implication or whether has the remedies that can be taken by any of the parties, and what are the implications to both parties. Okay, now we go to the introductory. So for this introductory, you can go through the reflection from what we have done before in terms of the difference between void and voidable. This is what have been highlighted, but in this lecture, I have highlighted some of the keywords. You can see the void is not enforceable, while a voidable contract, one of the party has the advantage, one of the party has the option to do so. Okay, please find back all this information in the previous lecture regarding to the voidable and void. Okay, so the focus for this lecture is for the void contract, where it is basically considered as no contract at all, no binding obligation by both parties, considered as unlawful or maybe not enforceable. Okay, when we talk about void contract, we can say that the contract without having the sufficient element of the contract, or we can say those or having any absence of the element of the contract will make the contract to be void. Okay, for the void contract, it also referring to the contract that is illegal. Okay, any party in the contract has no right or obligation. We can also consider as the contract is never existed. So no one has to take responsibility to claim from any of the party. In Malaysia, illegal contract also considered as void. In the Commonwealth country, basically all illegal contract are also considered void. That means no legal right, no obligation. It cannot be enforced because some of them are considered unlawful. Okay, unenforceable by either party. That means either party offerer or offeree, not enforceable. One of the example, a gambling contract. Okay, a gambling contract is prohibited. It is not being enforced by the court, even if neither party raised the defense of illegality. Even though at the earlier stage, maybe the plaintiff say that actually, I would like to sue him because he would like to contribute. But then the nature of the contract itself is gambling. So the court say that, okay, this contract is not considered a contract because no contract become into existence when the content of the consideration or the content of the contract itself is unlawful. Right. If one of the parties to the contract has diminished any of the capacity, maybe by referring to the age of minority. Age of minority means they don't have the legal capacity, or maybe has the issue of mental disorder, has the issue of mental condition, the contract will be most likely to be unenforceable. Okay. Now, if you look at the relationship between the issue with what we have learned before, fraud or misrepresentation by any of the party can void the contract, as the contract can violate the controlling law. So this is basically as the introductory to reflect what are the implications between all the issue. Okay, the focus for the lecture for today is regarding to the void contract. Basically, I can divide it this one into two. The scenario in the void contract and in the common law in the Commonwealth country, there is the difference between void and illegal contract. Illegal contract are referring to the contract that are unlawful, forbidden by the statute, forbidden by the country, or unlawful contract. Okay, so the agreement without consideration is void. This is one of the issue. Okay, now if you look at the word consideration, consideration is considered as one of the element to form a valid contract. So you can see that the absence of any one of the element of the contract will make the contract to be void. Okay, you cannot say that the absence of the consideration will make the contract to be voidable. We can just say the contract is void because the absence of consideration. Unlawful agreement made agreement to be illegitimate and cannot be performed. So this is another issue, unlawful agreement. Okay, we have three main issues that we would like to consider when we are referring to the issues in the void contract. Okay, now let's look at section number 21, mistake of the fact. If you remember previously, we have to make sure that both parties must have mutual understanding. Mutual understanding or mutual consent is one of the issue that clearly mentioned in the Commonwealth, in the English common law, and also impliedly mentioned in the statute. An example of the void agreement is the agreement entered due to the mistake of the fact. Okay, one of the example that you can see here, where one of the party think that they would like to sell Inspira, but actually another party thinks that he would like to buy Mitsubishi Lancer. The design are similar, but the engine are different. This is a simple example for you to reflect with what we have learned before. Okay, where both parties to an agreement under the mistake as to matter of the fact. Matter of the fact means the content of the fact essential to the agreement means the agreement is what. At the time the contract is going to be carried out, okay, let's say at the time where they would like to switch between payment and the car, at the time they think, oh, I thought you would like to sell your Inspira, because maybe the person has Inspira and Proton Inspira and also Mitsubishi Lancer. This is example. Okay, let's say the person has Inspira and also has Mitsubishi Lancer. So when B would like to buy, at the time B would like to pay, B mentioned to A that, oh, I thought you would like to sell your Inspira, but actually A would like to sell his Mitsubishi Lancer. That is the example. So at the time where he mentioned about that, the contract is void because the mutual understanding is not met. That is under to the mistake of the fact. So every time we are talking about the mistake of the fact, we are referring to the referring to the absence of the mutual consent, means the meeting of the mind between these two parties are different. Okay, now look at another example. Tony purchased a desk believing it is an antique from the expensive wood. His belief in this regard was based on his own judgment, okay, and not on any representation made by the seller. Not by representation means the seller did not make any statement. Later, Tony learned that the desk was an imitation of an antique and worth significantly lesser than the amount paid. Tony, in this case, has made a mistake in the judgment as to value of the quality of the wood. Okay, but in this case, you can see that because the buyer did not say anything, just because of his judgment, the seller did not mention anything about the item that he would like to buy. It is just the judgment by the buyers thinking that this is expensive wood. So that is giving the implication that the buyer cannot do anything. The contract is not affected by this mistake because Tony is not having the right to claim on something that is belong to his own judgment. Tony cannot cancel the contract as the mistake was only on his part. He did not mention something, and he also cannot prove in this scenario that the seller has made wrong representation, where in this case, maybe if you would like to think about the issue of fraud, it may be happen if the seller has made the statement or if the seller has the intention. And then number two, you can only can claim this one under the issue of misrepresentation if the seller mentioned something but that statement is wrong. He believed it to be correct. So that is misrepresentation. But in this case, it is just because of his own judgment, the contract cannot be cancelled. Okay, so this is another issue that we have to consider under mistake of the fact. That is also considered as mistake with mistake done by his own. Okay, because it's only the mistake on his part, on the buyer part. This is also by referring to the explanation or to refer to the clause stated under section 21 in the Contract Act. Okay, this is another example of the court case Freeman versus Kiamesha. In this case, a guest of a resort misread an advertisement. Can you see that? Misread an advertisement concerning the Memorial Day weekend. Okay, when the guests look at the Memorial Day weekend entertainment, he or she believe that they are popular artists or entertainer perform on that day. So because he believed that the advertisement, he believed that they are performance made uh, on the Memorial Day, will be made on the Memorial Day. So the guests book 3 nights during the weekend rather than just one. Okay. Okay, we can say that the guest have been influenced reading the advertisement. So at the end, he know the truth that he know the truth that actually there will be no popular entertainer uh, giving the performance for these 3 days. Okay, so he would like to cancel part of this 3 days reservation. Mentioned that he think that he misread or he think that they are performance made by the singer or the artist. The court held that his mistake was factual one and it was unilateral. Unilateral means it is not by both party, it is only mistake by himself. Therefore, he checked out at the resort and before the end of the 3 days and has to be responsible and remain obligated to pay the booking of the hotel bill for the 3 days. Okay, he need to pay the hotel bill in the full amount of money for the 3 nights. So because if you refer to this court case, every time we refer to the court case, we have to look at the factual in the summary, and then the most important when we are discussing something, we have to look at what is a judgment court. What is a judgment by the court? The court said that this. Every time you see the word the court held, the word held are referring to the judgment made by the court. Okay. Now number two, section number 22 in the Contract Act mentioned that they are also issued in the mistake as to the law. It provides for cases where there is a mistake to the law. So basically under this section, a contract is not voidable merely because it is caused by the mistake as to any law force in Malaysia, not voidable. If there is something wrong with the statement, but that one is forced in Malaysia, it is not voidable. But mistake as to the law not forced in Malaysia, it will take the same effect as the mistake of the fact, as what we discussed before. Okay, and then number three, mistake of only one party. This is also relevant to be referred together with section number 21. The law relating to the mistake for one of the party considered as unilateral, and English common law also considered to be either void or unenforceable. This one also had been mentioned under section number 23 in the Contract Act. Look at the example of the court case. B made a successful bid at an auction to the sale for the sale of the public house. Okay, this is the scenario happened at the auction of the sale for the public house. Okay, but if you look at the second statement, under the mistaken belief that a certain field was included in the lot when it is fact, in fact, it's actually not. Okay, the certain field was not included in the lot. In the lot means in the land area. The contract was held to be valid by the English court because in this case, you can see the word mistaken belief that a certain field. Okay, in this in a scenario, for example, let's say you would like to buy one piece of the land. Okay, but when you are given the information about the piece of the land, okay, you did not know which one actually belonged to you. You just believe that okay, this is plot A, this is plot B, this is plot C, thinking that your the land that you want to buy is including A and B. You buy the land, but you did not make any representation or any statement or any question and answer or inquiry regarding this issue. But it is just like mistaken belief that certain area or certain field, or maybe in this example is B, included in the lot, or in also the scenario at the auction. So at the end, it is considered as unilateral because you think that information, but that information is not confirmed. Okay, so basically, we look at the last one under mistake as to the document. This is referring to the mistake as to nature of the document that he has signed. What if you buy something, okay, you receive let's say you buy electronic item, okay, you can see the T&C are there, terms and conditions are there, but you did not read. Or you buy a flight ticket but you did not read any exemption clause, or you did not read any terms properly, who is actually wrong? Okay, so that is the issue that we have to raise here. The general position is that a person is bound by the term of the contract that he has signed, and this firmly established in the case. This is the original case, Strange and Graucop. Okay, so in this case, you can refer to the judgment later. A shopkeeper brought from G a slot machine. Okay, and then L signed a sale agreement containing the following clause. Actually, this is the clause. Any express or implied condition, statement or warranty, statutory, is hereby excluded. Okay, so basically when we buy something, we thought that there are warranty and so on, but you did not realize that, about this word. So L did not read the relevant clause, which is in small print. It always happen like this, right? Can you see this one? Okay, L did not read. So when he did not read, what happened? He thinks that there are warranties, something that can be claimed and so on. The machine did not work and L sue for the damages. L tried to sue for compensation because he would like to get something back or something to replace and so on. It was held in this case that the clause was binding because L had signed the document. So whatever information that had been stated in the documentation, terms and conditions, even though you did not read, you are bound to be responsible. So in this case, there had been no misrepresentation, there had been no fraudulent issue, there had been no issue where the contract can be claimed under damages because the statement that I highlight in the box is considered enforceable and binding by both parties. So in this case, L is not be able to claim for damages. Okay, now we look at the effect of the mistake for a while.